Hello, everybody. I have Professor Tanya Novitz here with me. Tanya is a world-leading professor of labor law, and she's going to explain from her research about the Immigration Act and its consequences on precarious workers. Over to Tanya.
Thank you so much, Devyani. It's a pleasure to be able to speak to you about this and to share this information with our different viewers. So I'm going to talk a little bit about the implication of the Immigration and Social Security Coordination EU Withdrawal Act 2020. And as you know, this measure was announced in the Queen's speech in December 2019 after the election of Boris Johnson's government. And it was really intended, I think, as a piece of legislation as completion of plans for Brexit to end free movement of workers to and from the EEA and encourage what was described as a skills-based immigration system. The Migration Advisory Committee, the MAC, has been a little skeptical regarding the effects of ending free movement from the EEA and has observed that there is some potential here to cut off supply of skilled labor. So they have explained that despite the rhetoric of costs of free movement in terms of housing, education, benefits, actually free movement provided substantial economic benefits for the UK because it tended to be skilled workers who moved and they paid more in tax than they ever received in benefits. So you can also see that a large, in fact, a disproportionate percentage of skilled workers in the NHS also originate from the EU. So I also see this piece of legislation as an attempt to fudge the loss of skilled labour, which comes from ending free movement and Britain leaving the EU. So one of the cases that one of the issues I think that you've raised with me earlier, Devyani, is what are regarded as skills by the UK government. And I think that this is a really interesting question because the new system is described as a points-based system, which is sensitive to skills. But it's a peculiar one because it has to be tied to a job offer from an employer. So it's not a points-based system like the one in Australia, where if you score a certain number of points, you can enter, even without potentially the promise of employment. In this scenario, the mandatory criteria for entry will include, under the immigration regulations, the immigration rules, a job offer. And the other mandatory criteria are that the job has to be at or above the minimum skill level. So it has to be A-level or equivalent, and the person concerned must speak English to an acceptable standard. And if you meet that mandatory criteria, that gets you 50 points. You need 70 points for entry. So you get that if you're paid the higher of the general salary threshold, £25,600. That gets you your extra 20 points on top of your mandatory 50 points, and you get the 70 points you need for entry. And that salary level is interesting because it is down from the previous £30,000 for Tier 2 visas. If you get paid less, but at least £20,480 per annum, you can get the extra points you need by satisfying other criteria, kind of trading off, if you like. So a PhD, like the PhDs that you and I have in the social sciences, would get you 10 points. A PhD in a STEM subject would get you 20 points. Job in a shortage occupation would get you 20 points. And also, if you're a desirable new entrant to the labour market, as designated by the MAC, you can get particular points. And there's a lengthy appendix which deals with that in the new planned immigration rules. So that's, I suppose, what skill means. A lot of skill seems to just mean salary. And as an Australian sociologist, Anna Boucher, has pointed out, that may be indirectly discriminatory against women, given the gender pay gap. There are also some important hidden exceptions to this skilled-based access to the UK labour market. One is that there's a seasonal scheme for temporary agricultural workers. There's a global talent scheme. You can buy a way in or be one of the elites, for example, a footballer who's in demand. And of course, there's the free port system, which I'll come back to in a moment. Of course, also, Irish citizens get treated differently, both from the north and south, and they retain free movement rights. So another issue that I think you've raised in your analysis, Devyani, is how fixed are these rules, and the capacity to change the new statutory provisions with reference to what we call a Henry VIII clause, which enables amendment of both primary and secondary legislation and seems highly problematic. So we would expect amendment of secondary legislation, the immigration rules, to be possible through ministerial powers and reported appropriately to Parliament. But what is problematic here is that the Act contemplates amendment of primary legislation through ministerial powers in consequence of or connection with the repeal of free movement law by Part 1 of the Act. And that's said to enable the government to align existing immigration laws for EEA citizens with those for non-EEA citizens. In part, that flexibility is being kept in contemplation potentially of whatever a Brexit trade agreement holds. But it seems to me dangerous because it reduces transparency and scrutiny by Parliament. It also means that immigration status is not something on which those coming to the UK can actually rely. The ground can shift from under them in ways that really reflect, fail to reflect their attachments to people, places, and their work. And that is frightening, I think.
Yeah. It's really great to hear your analysis on this. I wondered if you could tell us a bit about the free economic zones or the ports that we discussed earlier.
Absolutely. So this free port system looks like something new. So as I was saying earlier, the whole idea of the new immigration legislation of 2020 was to prioritize movement of skilled workers to replace those who might otherwise have come in from the EU on free movement. What it also changes is that it looks like it'll no longer be possible to temporarily post workers between the UK and the EU and get skills in that way. Now, that was a really problematic aspect of EU law. Workers moved as their employers exercised their rights to free movement of services. They were only temporarily resident in the UK, and they could be subjected to forms of exploitation, kept in particular forms of housing in the East Lindsey dispute and barges on the harbour, and paid at much less than the going rate for the work performed. And these temporary workers could be supplied by an agency or their current employer. Now, that practice of posting, which was never a great practice, is going to be ended on leaving the EU. But it may still be part of any future trade deal between the UK and the EU or a free trade agreement with other states. And conservative policy papers, proposals from the Confederation of British Industry, the CBI, indicate they're really interested in promoting further temporary posting of workers under free trade agreements or under the General Agreement on Trade and Services, GATS, under WTO rules. So where this kind of temporary migration, temporary movement of natural persons for work might take place is in the government's new proposed free ports. As I said, free ports are treated as a new innovation, but after I've described them to you, it'll be pretty clear that they look like the notorious export processing zones, the EPZs, which have been criticized by the International Labour Organization, the ILO. And in these EPZs, exploitation of domestic home workers and migrant workers is notorious. And here what I'm doing is drawing on a blog which Manoj Diaz-Abi and I wrote together on the Johnson government's plans around free ports. Free ports are interesting because they're a response for the need of the UK to become really competitive in trade if it leaves the EU. And free ports are designed to convert British ports and nearby inland centres into so-called hives of innovation. The idea is that they will attract foreign direct investment, and they will be hubs which will evade standard rules regarding trade in goods and services, and especially tariffs. So these could be potential assembly points where imported goods on ships or in other ways are going to be converted into viable exports, or they're going to be a place for delivery of particular sorts of services. The government initially launched a consultation on free ports, which Manoj and I wrote about. And now in October 2020, we have a response by the government to its initial free ports consultation. And that talks about how free ports should go ahead. How can there could be investment in these zones. They suggest that there will be different tariff rules that will apply, perhaps even thwarting the reversion to WTO rules, which the government has much wanted. There will probably be tax exemptions, and there may be a different regulatory regime that can apply here. And these are going to be both geographically and potentially sectoral zones in industry. And these EPZs then raise those ILO alarm bells that normal labour standards may not be enforced. From past experience in other countries, we have seen temporary migration into these zones, lower rates of pay, different regulations of hours and holidays, for instance. The government has said they see free ports as a way to enhance British workers' skills and apply these. So they say that British workers will work then within these zones. And they say that academic institutions like ours could train potential British workers to work in these zones, particularly providing the STEM skills that are required. And again, that could be in an actual port or inland. What about the labour standards for the British workers or perhaps the temporary migrant workers? The government does talk about equality, and they think about equality impacts in so-called BAME, BAME terms. They consider that there could be vulnerability in this process and that they will take precautionary measures regarding training and treatment of ethnic minorities. They don't talk about migrants. The government doesn't address other core labour standards recognised by the ILO, such as the need to prevent forced labour or provide collective labour rights, such as access to trade union membership, representation in collective bargaining, or, and this is probably not surprising, they don't talk about access to collective action like the right to strike. Essentially, freedom of association rights are not mentioned. They're not identified as important. So if we're thinking about other core labour standards apart from discrimination, there is the outstanding issue of forced labour in ports. And that has even been acknowledged by a think tank, Policy Exchange, which is known to pursue a conservative, if not a largely neoliberal agenda. And Policy Exchange has brought out its own report, which talks about free ports as a way to build maritime power and economic success in building a better future for post-Brexit Britain. But even they acknowledge the problem of forced labour in ports at present, and they note that since COVID, over 300,000 seafarers have been trapped on boats. Their contracts have expired, but they've not been permitted to leave their vessels. And instead, they're subjected to forced labor, virtual imprisonment on board. So the Policy Exchange report suggests that this is the sort of issue that the UK government could address, and that forced labor could be prevented on vessels and free ports, applying International Maritime Organization and ILO standards. But I think it's telling that there's no mention of that in the government policy at present. So I guess, in short, all the surrounding issues around this important recent piece of legislation, the Immigration and Social Security Coordination EU Withdrawal Act of 2020, do not look good. And I suppose that's interesting for us all in terms of wider migration practices.
Thank you so much, Tanya, for your expert insights on how these provisions will particularly affect precarious labor and increase precarity. I also think I'm going to put the link to your blog post, Manoj, and yours, so that readers can also read up more of the analysis. And thank you very much for coming to speak to us today.
Thank you so much, Devyani.